of California.
Okay.
So does that mean you will do further soil testing, or?
It has been assessed to the point that we felt satisfactory that anything that was found was remediated to the levels that are established in the state.
Aaron Beverly, McCloud. First question in regards to the groundwater. You're taking that off the table. I'm wondering if you're planning on putting that into some kind of legal binding agreement. And the other thing, I just wanted to follow up on Meadows' comment. The case of Freiburg and Mecosta County, Michigan are very important to us, and I think it's requires a little bit more discussion than was just had. Our understanding, or my understanding, is in Freiburg, you have been suing the township. In the case of Mecosta County, you have been sued because the science has indicated that there is harm to the watershed and you were not reducing your water outtake. And so that town had to sue you to get you to do that. So I think it's important that we have a serious discussion around those issues because it is important to us.
So first question about the groundwater, and then the second question regarding the lawsuits.
Well, okay, I'll take care of the groundwater question first. Anything's on the table for discussions. Like I said, we don't have a binding agreement now, but that's certainly something that if that's what the district wants to make everyone will feel comfortable in a new contract, that no groundwater wells will be allowed or considered for this plant, yes, we're willing to.
It's also, if it's not part of the CEQA document and not part of the process, then it's not allowed. And so you can't do it if it's not part of it. If you don't put it in part of the CEQA process, then obviously groundwater wells aren't allowed as part of the project. Going back to Freiburg, first of all, we operate 26 plants across North America. And we operate a number of spring sites above that 26 plants. You might think from the internet we operate in 2 places in North America, and that would be Michigan and Freiburg, Maine, and quite frankly, it's very different. And I think that around North America we have a harmonious relationship with our host communities, and we get along very well with those communities. To address Michigan specifically, we were sued in Michigan by a landowner that felt like their riparian rights were being violated by the extraction of water by Nestle. That went to the circuit court, in which case the circuit court ruled against us. There was an appeal by us to the Court of Appeals. That Court of Appeals put a stay in and then ruled that the circuit court ruled that Nestle has a right to its fair participation of water. It's a legitimate business. It's a value-added business in Michigan. It has its right to its fair participation of water. But the property owner also has its right to certain riparian rights, as part of the water, okay? So the Court of Appeals then sent it back to the circuit court and said, listen, here's the rules that you have to follow when you decide on a case between a riparian owner and Nestle. And so Nestle met with the other side, the plaintiffs or defendant, the plaintiff, I forget, it's the other side. Plaintiffs, thank you. Nestle, we met with them and we had an out-of-court settlement. That out-of-court settlement was in early 2006. And that out-of-court settlement had a series of reopeners with it, 4 years, and then, or 2 years, and then 4 years, and 5 years, and a number of reopeners past that, okay? And then it had a sunset on reopeners. You couldn't reopen it anymore. So our first reopener was in 2008, where we sat down and tried to confer again and said, can we reach another out-of-court agreement? And it would appear that we cannot reach that out-of-court agreement, and we're heading back to court to set what would be the withdrawal rate for the next period of time. Okay?
Thank you.
So that on Freiburg, can you, just to make sure we're on the same page here, explain to me what your thoughts are on the Freiburg lawsuit so I can appropriately respond. What do you believe that the lawsuit's for?
My understanding. Hello. My understanding is it revolves around the issue of a trucking station.
Okay. So in Freiburg, Maine, we have an existing trucking loading station at the spring site. The spring site's owned by the Freiburg Water Company. We, at the same time, in the town next to Freiburg, Denmark, there was another spring site there. And our intention several years ago was to develop that spring site and have a short pipeline out to a road called Route 302 and have a load station on Route 302. That load station property is in the town of East Freiburg. Okay, so we have a spring site in the town of Denmark, and then we have a pipeline that goes out to a road, and that property with the load station would be in East Freiburg, or Freiburg, let's say. So we applied for our permits for the Denmark Spring, and we applied for our permits for the load station for East Freiburg. And we received those, at the Planning Commission, we received those permits. And then the approval was sent to the Zoning Board of Appeals. And the Zoning Board of Appeals then changed the ruling of the Planning Board and ruled against the citing, the approval of the load station. And so Nestle then said, no, we don't agree with the Zoning Board of Appeals. We agree with the original Planning Board decision. And where do you take, if you don't agree with the Zoning Board of Appeals, then you take your decision to the court, to the court system and say, you know, we got a permit from the Planning Board. It was overturned by the Zoning Board of Appeals. And the next step in that process, if we didn't like that or they didn't like that decision, is to go into the court system and have someone in the court system decide, was the Planning Board right or was the Zoning Board of Appeals right, as to allow or not allow the load station in East Freiburg on Route 302. So in Freiburg, it is us that is said, no, listen, let's go into the court system because we want to know if the Planning Board decision was right or the Zoning Board of Appeals decision was right.
Okay.